is also on the agenda. The BBC's Leila Nathu reports.
In his address to finance ministers gathered here, India's Prime Minister Narendra Modi made no reference to Russia's invasion, only mentioning rising geopolitical tensions. India is maintaining a neutral stance on the war and wants to have a very different conversation here. It wants to use its presidency of the G20 to champion the needs of developing nations who don't have a seat at this table of major economies. So India wants discussions to focus on food security, sustainable growth and debt burdens.
As the meetings convened on the one-year anniversary of Russia's invasion of Ukraine, such issues were bound to crop up, despite host India's reluctance to be caught between the allies of Ukraine and Russia and other countries. More on the
following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Oh, hi there, and welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Today is Saturday, February 25th, and we will be with you for the next hour to do one thing and one thing only, and that is further educate your legal knowledge, whether it's me reporting on an interesting topic that I want to discuss, or whether it's by answering your legal questions. You can call in now. The law office is open studio lines. And Brian, the call screener, standing by, eagerly awaiting to screen your call. 877-943-9673. Again, that open studio line, 877-943-9673. You can always email your questions directly to me, Patrick at attorneypatricksmith.com. And boy, did you email questions last week when we kicked off the show kind of last minute and sort of haphazardly, just hearing in the opening news for the top of the hour about euthanasia. You did fire off some emails regarding that. And today, pending time, we're going to read some of your listener email regarding whether or not euthanasia should be legalized here in the great state of Florida. So your email questions always read and responded to, and we try to get to them on the air as best we can as well. So if you want to email me directly, 24/7, the email address is good. That is Patrick at attorneypatricksmith.com, Patrick at attorneypatricksmith.com. But we always love to talk to you live over the air. That number, 877-943-9673, 877-943-9673. Give us a call now, live and local question. Always curious to see who the first caller is going to be and what that question is that's going to kick off the show. So give us a call now and we will be happy to help. So to kick off the show with what I wanted to discuss today, this topic came to me from my lovely bride, who, I don't know how it missed my radar, but there was a very interesting case that comes to us out of South Florida. And it actually, just to kind of set up our discussion of this article from the U.S. News and World Report, I want to go back to a previous discussion that we had back in June. So back in June, we discussed the landmark case of Dobbs versus Jackson, which is where the Supreme Court overturned the lower court's decision in that case 6-3. But the bigger news was the 5-4 vote on overturning Roe versus Wade. And that, of course, was, the match hitting the powder keg, reigniting the abortion debate in this country. And subsequent to that, you've had a lot of new debate going on where people say that women should have the right to choose versus we have to protect the life of the child. So many say that women have the right to choose about the life of their unborn children. However, many pro-life advocates often ask, does the unborn child have a right as well? And if the child does have that right, or in other words, who should be responsible for protecting that child's right if they have it, if the mother is not willing to make that choice? So that debate has reignited, and it is taken a particularly hot example coming out of South Florida. According to an article by U.S. News written by Antonio Planas, a legal petition was filed this week that seeks to free an 8-month pregnant Florida inmate who says her fetus is receiving inadequate medical care while she is in custody. The petition filed Thursday in Florida's 3rd District Court of Appeal demands the release of the fetus from the Miami-Dade Corrections and Rehabilitational Department because it has received limited prenatal care since Natalia Harrell's arrest. Harrell, whose age is 24, is accused of fatally shooting a woman while they were in an Uber vehicle. She was charged with second-degree murder in August and has been ordered to be held without bond. According to court records, Harrell pled not guilty December 6th. Her trial is scheduled for April 18th. Attorney William Norris, who filed the petition on behalf of the fetus, after he was contacted by the father, said Tuesday that the unborn child is a person with constitutional rights. Once you define an unborn child as a person, then the unborn child acquires constitutional rights that apply to any person. And specifically in this case, that's the right to not be deprived without due process of law. And in this case, the unborn child has received absolutely no due process. So for those of you, the due process clause lives in the 14th Amendment of the United States Constitution. The article goes on to say the court should let the mother go into an environment that protects the rights of the child. The filing says officials have failed or refused to take the unborn child to attending OBGYN physician at Jackson Hospital, saying the last visit the mother had was in October. The court filing also says Harrell has not received prescribed vitamins and nutritional drinks during her pregnancy. A filing by the respondents, the Corrections and Rehabilitational Department and its director, argues that the petition should be dismissed because it's beyond the scope of when a subject should be released, and says the mother and the unborn child care are a priority. Quote, the state of Florida, however, does not take the allegations contained in the petition lightly and recognizes the importance and absolute necessity for a pregnant woman and her unborn child to receive adequate medical attention and treatment. The court documents say the state communicated with all respondents on an emergency basis to ensure petitioner's mother and unborn child are being treated well. A Corrections Department spokesperson said in an email Tuesday that this agency would not comment on an ongoing case, but did speak in general terms about medical care for pregnant inmates. Their statement, we are committed to ensuring all inmates receive professional, timely medical care and all appropriate treatment. The statement said, we are conducting a full review of the health services offered and received to ensure that all prenatal care being provided in our custody is appropriate. So I turn it over to you, Attorney Patrick Smith, Show Nation. What are your thoughts? Should the mother be released despite her alleged crimes for the sake of the unborn fetus? So that's the question we pose to you today. 877-943-9673, 877-943-9673. Give us a call now. Open studio lines. We'll get you right on the air. All right, let's go to Lake Placid, and we're going to talk to Thomas. Thomas, welcome to the Attorney Patrick Smith Show.
Morning, sir. Just started listening to your show a couple months ago. Really like it.
I appreciate your kind words. Thomas, how can we help you today?
Well, I have a question about what are the advantages or disadvantages in setting up a trust. I happened to catch something a couple of weeks ago, and I missed most of it.
So did you have a question specific, or did you want me just to sort of outline the general advantages of trust?
Just a general advantage, I guess, probably.
So first of all, there's lots of different types of trust that attorneys do, Thomas. And the most popular one that I see on a day-to-day basis is the single or simple living revocable trust. The revocability of it, meaning you have full control, you can change any part of it, you can put assets in, take them out again, change your beneficiaries, trustees, do whatever you like. And the big advantages, sort of in a crescendo style fashion, I think, are number one, the trust is a private instrument. It'll keep it off the public record so that not everyone will see your sensitive family bequest. I think number two, it provides incapacity planning, which is something a will can't provide. A will is strictly a post-mortem document. It's designed for only after you've passed away. In other words, if you develop dementia, or you have a car accident, you're in a coma, the will doesn't do you any good. The personal representative can't seek not appointment or confirmation of their nomination until you've actually passed away. A trust provides a way for a successor trustee, commonly after two doctors have determined that you're no longer able to serve as trustee of your own trust, for that successor to take over to protect the assets, the corpus of the trust, for your best interest while you're still alive. They stand around it and shield it from sometimes greedy family members who want to come after the assets. More commonly, it's aggressive creditors like nursing homes or other medical institutions who will, often dramatically spin down an estate. So I think number one, we see, it's a private instrument. Number two, it's a document that provides incapacity planning. But number three, the number one thing you hear people say, the positive about having a living revocable trust, is it avoids what? Do you want to take a guess, Thomas?
I would think creditors coming against you.
Well, it can. There are those types of trusts, but the number one thing it avoids is probate, which there is a process by which you can establish the trust. And because the trust is a living trust, it's a separate entity from you, fully owned and controlled by you. That, by definition, when you pass, can avoid probate, because probate is defined as assets going from a deceased person's name to the appropriate living beneficiary person. So at the end of the day, the trust is this separate entity, like a safe that you can put assets in, take them out again as you please. And then when you've passed away, it will transfer those assets to your beneficiaries through your successor trustee, minus the probate process for all the assets in the trust. So those are the big three: privacy, incapacity planning, and avoiding probate.
Okay, so it does probate out of the picture.
Yeah, I think anything in the trust is going to avoid probate. It's not a guarantee that the entire estate will avoid probate. And I can demonstrate that for you, Thomas. It's a situation where someone did a trust and they had all their assets properly titled in the trust, but they died in some sort of accident that generated a wrongful death settlement. Well, you couldn't put the wrongful death settlement in the trust because you didn't know about it at the time the settlement actually came in, because you had passed away. So you couldn't move it to the trust. So that's why we commonly do something called a pour-over will. And this is all included in our standard trust package, the $695 trust package, which covers the trust, pour-over will, power of attorney, healthcare surrogate living will, deed for the home. And that makes sure that everything's properly funded into the trust that we know of. And then the pour-over will is designed to capture unanticipated assets or assets that come into our estate post-mortem.
All right. Now, is this something that, say, a local attorney could do here? I mean, we're nowhere near. We're probably 3 hours from any of your offices.
Yeah.
Is it something that we have to come in and see you, or
you can
any local attorney?
So Lake Placid, you're right. I don't think we have an office quite in Lake Placid yet, but no, you're welcome to work with any estate planning attorney. I think you just, if you want to contact a local attorney and then interview a couple of them, find one you feel most comfortable with, and then go from there.
Okay, because we did our will through our local attorney's office. He's since retired. I don't know who's taken over, but is that something they would normally do if they did your will?
Yeah, I think if you had a local attorney, reach out to his office, and if he retired, he more than likely put a successor there. So just reach out to the successor, interview him. Maybe you'll like him just as much. Maybe you'll like him more than your former attorney. And just sit down with them and say, hey, we'd like to talk about creating a trust, and then go from there. So if you've got, a good existing relationship, there's no sense in rocking that boat.
Okay, perfect. I appreciate your thoughts. Thank you very much.
You're welcome. Thomas, what station are you listening on down in Lake Placid?
1025 The Bone.
All righty. We appreciate you listening, Thomas. Enjoy the rest of your Saturday.
Thank you very much.
All righty. 877-943-9673. That's your live and local number. We are happy to take any of your legal calls today. 877-943-9673. We kicked off the show discussing the petition filed on Thursday regarding the release of a 8-month pregnant woman from a South Florida corrections facility, claiming that the fetus was being unlawfully detained without being given proper due process under the 14th Amendment of the U.S. Constitution, which, by the way, procedural due process refers to the constitutional requirement that when the federal government acts in such a way that denies a citizen life, liberty, or property, in this case, liberty clearly would be the accusation by the filing attorney, the person must be given notice, the opportunity to be heard, and a decision by a neutral decision maker. So the attorney filing this petition essentially saying the unborn fetus not being given due process and therefore should be released. So maybe you have an opinion on that or any other legal question. 877-943-9673. 877-943-9673. A couple of thank yous to give out. Thank you to Pastor Ray and the Indian Rocks Foundation for hosting my presentation this last week at Smiley's. Absolutely packed house. I think it was standing room only by the time everybody finished filing in. Great Q&A that followed the presentation. So absolutely wonderful turnout, and always look forward to speaking at Indian Rocks. So look forward to being back there soon. Also be there in March for the Solo Parent Conference. So stay tuned for more information about that. Also, for those of you listening on 90.3 FM and Gospel 90.3 WLVF in Haines City, producer Doug and I actually talked this past week, and I will be making a personal appearance this Thursday for Restore-a-thon. So I think I'm scheduled there to roll in just before 2 o'clock. And then be on with you guys for your Restore-a-thon for an hour or so. So if you're in the Haines City area and you want to meet me, I'll be there, from that 1:45 to 3-ish range. So you can come out, and love to shake your hand and meet you in person. So if you would like more information, you can check out Gospel 90.3's website at gospel903.com. All right. But we want to talk to you live today. 877-943-9673. Open studio lines, 877-943-9673, or email me, patrick@attorneypatricksmith.com. All right, let's go to Fort Myers. Let's talk to Stephen. Stephen, welcome to the Attorney Patrick Smith Show.
Good morning. How are you?
I'm great, Stephen. How's Fort Myers doing, by the way? Are they pretty much back up and running? Have we fully recovered?
Nowhere near it.
Nowhere near it. That's sad to hear.
No.
I'm sorry to hear that.
Annabelle's still good. Yeah, it is what it is. We're getting there. We're Floridians.
Well, the reason why I ask, it's so often you hear that initial report about the hurricanes coming through, and then, you hear about it for a couple of weeks, and then people forget about it. It falls off the news cycle, so you don't realize these people are still down there struggling. So, Stephen, even though it's not a great report, we appreciate your firsthand report that there's still a long way to go, and we'll continue to stand with all you guys in our prayers, okay?
Yep, we appreciate that.
How can we help you today, Stephen?
So just a couple questions on an LLC. I just started my own company. I'm a single member LLC, and I was wondering advantages, disadvantages. I've been told separate things. I need to put a second person on there. What is your thoughts?
I think it's a conversation that you have with two professionals in your life, at least. I think it's a conversation you have with your attorney. Do you have an attorney already representing you, Steve?
I do not, but I know one personally.
Okay. So what did the attorney you know personally tell you?
So I was told that being a single member LLC, say I was driving home from work and I get into an accident, that those people could come after all my personal property.
Well, so what they're trying to do essentially is make the argument for piercing of the corporate veil and basically say that there really is no LLC in place. I think there are protective measures you can potentially take by adding additional members, but that comes at a price. Now, if you have another member, you obviously don't own 100% of the business anymore, Steve. So there's that calculus that needs to be done. The other professional you want to involve in this conversation is your accountant. And then, of course, not to forget about the financial advisor. If you have a good financial advisor, it's really that triumvirate, the attorney, the CPA, and your financial advisor all consulting about how to optimally structure your LLC so that you're best protected from any potential liability.
Yeah, I was with my accountant 2 days ago, and he liked the idea of the LLC. And once we got to a certain number of gross, then to turn it into a partnership.
And I think if you do the partnership, have your attorney friend, if they're willing to do it and know how to do it, do a formal partnership agreement. And the more you put in writing with that partnership, I mean, I know a handshake deal feels good at the time, and there's nothing wrong with shaking hands, but, follow up and take the Gorbachev approach, trust, but verify, put it all in writing, Steve.
Right. And then if to add the wife on there, let's say I made her the second acting member, would that counteract being a sole member, or because we're married, would our assets be at jeopardy as well if that were the case?
Well, I think what you're aiming for there is the tenants by the entirety's protection. You're looking for all 5 unities to be present: time, title, interest, possession, and marriage. And that TBE protection may be available to you. But remember, it's all 5 unities. It's not just the fact that you're married. You took possession at the same time, same title, interest, possession, and you're married. So make sure, if your attorney friend is helping you with that, that you walk through that tenants by the entirety's analysis so that you get that protection in place as well. And that's the thing here, Steve. LLCs are not, there's so many people I think, register a fictitious name and think, oh my gosh, I finished my LLC, thinking that's the finish line, but it's the starting line. Setting up the corporate name, it's the operating agreement, the bylaws, it's the stock registry, and it's how well you maintain that LLC from that creation that determines how well protected you are should a liability pop up. So I think it's about ongoing analysis with your attorney and your accountant to make sure that you're operating it optimally so that you are best protected. You don't want any sort of weaknesses in this armor we're placing around your assets. And I think the tenants by the entirety's protection is another layer of protection. And then I think you possibly consider transferring your LLC interest to your trust, which can also have a potential creditor protection status if it's joint with your spouse, so you may not lose that. So it's about having all these different layers of protection on top of, after you consult with the financial advisor, saying, look, do I need additional insurance? Should I have additional liability insurance? So that's why I say it's a calculus of all these different moving parts.
Okay. Well, I appreciate it.
All right, no problem, Steve. What station are you listening on down in Fort Myers?
The station I listen every Saturday morning, 102.5 The Bone.
All righty, Steve. We appreciate you listening and enjoy the rest of your Saturday, okay?
All right. Thank you, sir.
Yes, sir. All righty, 877-943-9673. It's just as easy as Steve made it look. You call in with your question. We give you the best answer we can live over the air. It is 877-943-9673. 877-943-9673. So give us a call now. We are live and local, happy to help any way we can, or you can email me, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. And speaking of accountants, because we did talk about an accountant during that last call with Steve, get your tax questions ready. Next Saturday's show, Yumiko, I was wrong. I forgot. We actually have guests, not this Saturday, next Saturday. Next 2 Saturdays, we're going to have guests. I apologize. I was wrong.
Okay.
Next Saturday, we will actually have Dwayne Bischoff, our resident CPA, here in to answer all your tax questions since we're in the middle of tax season. So make sure you get those lined up and queued up for Dwayne. He'll be live in studio with us answering all of your tax inquiries. But if you want to talk to us today, 877-943-9673 or email me, patrick@attorneypatricksmith.com. All right, let's go to Bob. Bob, welcome to the Attorney Patrick Smith Show.
Hi.
Hey, Bob.
Am I on the air?
Bob, you're on the air. Are you a first timer?
I am a first timer. I listen to you almost every Saturday, but I've never called you before. But
well, Bob, we appreciate
you mentioned the due process, and unfortunately I'm probably calling you after the horse has been stolen from the barn.
Well, go ahead.
My divorce just finished. I believe if I could afford the appeal that I would win, and so did my attorney, but I simply can't afford it. I've already spent like $65,000 trying to protect my rights. Should have had you write something up earlier, but I didn't. But the judge used jurisprudence to basically circumvent the homestead laws, or my Social Security. I'm either going to have to borrow against my homesteaded house to satisfy the judgment, or she's going to force me to sell the house. And she gave herself the authority to force me to sell the house, even though neither very experienced attorneys thought that she could. And I listened to the debate in the courtroom between the 3 attorneys, and both the defense and the other attorney, my attorney, thought that the judge couldn't partition the house because it was just in my name and my wife wasn't on the mortgage or on the deed.
Yeah, and last Saturday we also did our Homestead 2.0 show, kind of recapping a previous show we did because of the March 1st deadline for filing for homestead. And one of the points we covered in that show, Bob, was if you have a homestead property and it's just in your name, the mortgage is just in your name, or there's no mortgage at all, and you say I do to someone, that spouse has rights to that home. And the rights are given under state constitution and state statute. The constitutional rights say that if you want to alienate or transfer that property, you may only do so with spousal joinder, meaning the spouse is required, even though her name's not anywhere on the deed. And so that's where it gets you from the constitutional side. And then from the statutory side, the spouse has the right to inherit that property. And if there is nothing about her name on the deed and nothing about her name in any of the estate planning documents, they can still take the right to live there for life, or within 6 months of your date of death, file something called a tenant in common election. And that's taking half the value now. So those are the rights that happen just because you say I do. And the way to address those adequately without having to have these surprises should you wind up getting divorced, and I'm very sorry to hear that you had to go through a divorce, Bob, you need to do a good prenuptial agreement or a good postnuptial agreement with your attorney, and that should avoid that issue. So go back to your attorney, have that conversation, I think. And if you want someone just to give you a second opinion on it, I'll be happy to review the court's opinion and see if I can help explain it. But my guess would be your current attorney will probably do a fine job explaining it. So start there. And if you need a second opinion, we'll be happy to help you.
Well, I listened to your show, and like I said, the horse is out of the barn. The question is, it establishes basically a precedent that I don't think was established before, and I don't have the money to appeal it.
Well, it's an interesting question. I'd love to see the court's order, what exactly the court ordered, and then I can give you, because homestead.
I can send you all the information.
Yeah, feel free to send it over. We'll be happy to take a look at it.
And my attorney feels he could win. He does not feel he could win in reconsideration. He said this judge isn't going to budge. He does think it would be at least heard in appeal. But I can't afford it. I mean, it's another $40,000-$50,000.
Yeah. So right now you're really shopping appellate attorneys, really.
Oh no, my attorney is an appellate attorney. He's very, very good.
Okay.
He's one of the best in Florida.
Well, there you go. So you've got the right attorney. You just got to find one within your budget, it sounds like.
Yeah, I'm wiped out.
Oh. Well, Bob,
I'm wiped out.
I
know.
How many years were you married, Bob?
8.
Wow. I'm sorry that happened.
I'm sorry. 7 when she filed. I got taken. I didn't realize I married debt. You know, Florida has financial disclosure at marriage. It does not, or I'm sorry, at divorce. It does not have financial disclosure at marriage. I gifted her a house and she gifted me a lot of debt.
Well, Bob, I'm sorry to hear that. But, you know, I heard a pastor say recently, there's a reason why the rear view mirror in the car is so small and the windshield is huge. That's because God wants us looking forward and not back. So nothing you can do about the last 8 years other than learn from it and move forward the best you can. But we'll all be praying for you and hoping that life turns around. Okay.
I appreciate that. Thank you. Is there somewhere I could send this to you?
Yeah,
you could look at it.
You can just email it to me directly, patrick@attorneypatricksmith.com. I'll keep an eye out for it and we'll give you our 2 cents on it. Okay.
Very good. Thank you.
You're welcome, Bob. Have a great Saturday. Okay.
You too.
All right. 877-943-9673. 877-943-9673. That's your live and local number to be part of our show today. Open studio lines. Brian, the call screener, currently queuing up some calls. So 877-943-9673. If you want to reach out to me at the office during the week to schedule your complimentary consultation in the Clearwater, Sun City Center, Sarasota locations, that is 877-754-6764. Again, the office line, Monday through Friday, 8 a.m. to 4:30 p.m. You can call 877-754-6764, and you can speak with any member of the staff, and they will be happy to get you on the calendar. Again, that office line, 877-754-6764. You can also email me, patrick@attorneypatricksmith.com, or just visit the website, attorneypatricksmith.com. You can request an appointment there by submitting a message. That's also where, by the way, you can go back, click on the radio link and listen to archived radio shows. So if you want to hear old broadcast or you missed something, you want to take some notes on our Homestead case, or like today we were talking about our Dobbs versus Jackson discussion back in June, you can go back and listen to all of our archive shows at attorneypatricksmith.com. And again, the number to be part of the show today, 877-943-9673. All right, let's go to Chris in Tampa. Chris, welcome to the Attorney Patrick Smith Show.
Hi, Patrick. How you doing?
I'm great, Chris. How's your life this week, buddy?
Oh, I'm still alive.
Well, praise God for
I
that.
guess that's all I can say. I didn't want to take up very much of your time. I just, on an estate, I just had two quick questions. My parents have both passed. I'm an only child. Can you just ballpark me on how quickly an estate can be established for my mother, and how much it would cost?
It depends. I mean, the short version is if it's an estate of less than 75,000 and mom's date of death was more than 2 years ago, maybe as little as like 30 or 45 days, depending on the county and the judge. If it's not, if it's over 75,000, I mean, it's a formal probate and it's going to require a publication of notice to creditors, then I think you may be in for something like a 6 to 14 month process. But it's impossible to predict, Chris, without knowing a little more. So that's why we offer that free consultation. So in the privacy of the office, we can give you our 2 cents on how long we think it's going to take and give you a written fee agreement quoting our fee.
Okay. Does this change the dynamic at all? There is no estate. The only reason I'm doing this is because there's a $4,000 or a $5,000 product liability claim hanging out there. So there is no. I mean, I obtained all her assets. Her bank account passed on to me. That's all it was. So the only reason really I'm doing this is for a $5,000 product liability claim that the statute of limitations is about to run out on.
Well, make sure you get with an attorney so that statute doesn't run. And then, yeah, I think that would affect it. It's possible you could do a simpler type of probate because of the size of the estate there, Chris. But get all that paperwork and make sure you get with a good products liability attorney to protect you on that and make sure that statute doesn't run, okay?
Okay, and are you going to, last night on the news, I saw there's tort reform going on in the state. Are you going to be covering that at all?
We are. And we're actually going to try to line up Attorney Jared Bailey, who's of counsel with us now because he's a classically trained personal injury attorney, and he will be able to speak most intelligently to what, if any, tort reforms come down the pike and kind of how it'll affect us in a practical sense. So yes, we are planning on doing a piece on that, and we haven't exactly lined up because we have lots of shows already lined up coming up over the next couple of weeks. But as soon as we can, yes, Chris, we do anticipate doing a special on that.
Okay, yeah, because I saw something that you would no longer, negligence would no longer be a viable claim to file a suit against someone, and that really concerned me. But it's a delicate balance, and I was just curious to hear what you have to say about it.
Well, stand by and have all your questions ready for the next show, okay?
Thanks, Patrick. Thank you.
All righty, Chris. Have a great day. All righty, 877-943-9673. Give us a call now, 877-943-9673. You can give us a call now. We're live and local. Happy to help any way that we can. And the other item that I had queued up for today's discussion, beyond the possible wrongful imprisonment of the fetus story that we kicked off the show with, was regarding grand juries. Now, grand juries are special, and in Florida, it's governed by Statute 905.24, and it says that the proceedings of a grand jury are to be kept secret. Now, grand jury proceedings are secret, and grand jurors or interpreter appointed pursuant to certain rules shall not disclose the nature or substance of the deliberation or vote of the grand jury. Now, why would they do this? They do this to protect the grand jury from becoming a target by the person who is the target of the grand jury. So secrecy is of utmost importance. Now, the particular story I'm going to cover here, not a Florida story, but as a Florida attorney, I felt obliged to state the Florida law on the case. But the law most relevant here is the law of the great state of Georgia, which basically says in their oath for the foreperson to administer to any member of the grand jury, you shall keep the deliberations of the grand jury secret. So why do I bring this up? I bring this up because the grand jury, the special grand jury that was appointed in the state of Georgia investigating the Trump administration, the foreperson, Emily Coors, I think I'm saying that correctly, Yumiko, the foreperson of the special Fulton County, Georgia grand jury investigating alleged illegal meddling of the 2020 election, is going around apparently and giving numerous interviews to CNN, MSNBC, and some legal observers are scratching their heads, especially in light of these laws saying you shall keep these things secret. Now, some legal scholars have said, I don't see any violation of that secrecy requirement. But here at the Attorney Patrick Smith Show, we would rather bring you the primary evidence, and we will let you decide. Call in. Tell us, do you think this is revealing something that's secret in a grand jury situation? Or is this not revealing something that is secret? Yumiko, how about we go ahead and let's play clip number 1. I think that'll be a good clip to start with. So Yumiko, go.
Did you personally want to hear from the former president?
I wanted to hear from the former president, but honestly, I kind of wanted to subpoena the former president because I got to swear everybody in. And so I thought it'd be really cool to get 60 seconds with President Trump of me looking at him and being like, do you solemnly swear? And me getting to swear him in. I kind of just thought that would be an awesome moment.
That's not doctored. That's the actual audio. So is that an example of revealing something that was secret from a grand jury deliberation? I mean, I don't know. I mean, we're asking you, so maybe you have an opinion on that. 877-943-9673, 877-943-9673. Let's go to Judith in Tampa. Judith, welcome to the Attorney Patrick Smith Show.
Yes. I'm calling because my son, he was married, and his wife moved back to St. Louis like 10 years ago. He had 2 children. And now, and she got a divorce from him in St. Louis, and he never had to pay child support. Well, almost a year ago, he got this letter saying that he has to start paying almost $800 a week in child support.
Does your son have a family law attorney?
For child support for his 2 kids that he didn't even know that he had. They said it was for back child support and everything, but he didn't even know because his wife had told him, never had asked him for child support, never was discussed for child support. He never knew. I mean, they were talking and he was seeing his kids and everything, but she never, no child support. She goes, I don't want no child support. So now all of a sudden they want the lawyer or whoever saying that they want like $800 a week for child support.
So I go back to my original question, Judith. Did your son have an attorney?
No.
Okay. So when he received this letter, was it just a letter from an attorney or was this a court order?
I believe it was a letter from an attorney because he hasn't been able to pay because he doesn't have the money.
No, my question was the correspondence that your son received from the former spouse, was that a court order or was it just a demand letter from another attorney?
I think it was a demand letter from another attorney.
An attorney in St. Louis or an attorney in the state of Florida?
Nope, St. Louis.
Okay. So I think what your son needs to do is contact a family law attorney, review that letter, and then decide how best to respond to protect his interest, okay? If he needs help finding one, have him give me a call if he's a Florida resident and does not have an attorney, and I will be happy to put him in touch with a couple of family law attorneys that can assist him, okay?
Thank you so much. And just have him call this number that I just called?
Well, that's the studio line. If you call that number, they'll be happy to pass on the office line, but I'll give out the office line here before we wrap up the show, okay, Judith?
Thank you so much.
All righty. Have a great day, Judith.
You too. Bye-bye.
Bye-bye. 877-943-9673. That's your live and local number. I just see we got a message over Facebook. Because, by the way, for those of you who want to watch the show live, you can go on Facebook and search Attorney Patrick Smith and watch the show live. But we got a greeting from Carol in the British Virgin Islands. Wow. I think that's our first message from the British Virgin Islands. I know we've had several states, I think California, New York, but Yumiko, I don't think we've had anyone from the British Virgin Islands yet.
No, we haven't.
So, hey, Thank you, Carol, for messaging from the BVI. We appreciate that. So 877-943-9673. Give us a call now, live and local. Happy to help any way we can with your legal topic. I did promise Judith that office line for those of you out there eagerly waiting for how to contact us during the week to schedule an appointment. 877-754-6764. 877-754-6764. That's your office line to talk to us during the week, Monday through Friday, 8 to 4:30. 877-754-6764. But we always like talking to you live on Saturday mornings. That number, 877-943-9673. Before we took Judith's call, we were talking about the special grand jury. It was appointed to investigate the alleged wrongdoing by the Trump administration, meddling allegedly in the 2020 election in the state of Georgia. And we were talking about how the foreperson for the special grand jury, Emily Kohrs, was basically doing a media tour, giving interviews. And we were asking you, the listeners of the Attorney Patrick Smith Show, whether or not her interviews and her comments made during the interviews were a violation of the requirement that grand jury deliberations remain secret. So I think clip 2, Yumiko, let's go ahead and play clip 2, and then we'll see if anyone wants to call in and express an opinion as to whether or not, and I see Brian's screening calls now. So go ahead, clip 2, please.
I can't. Well, I might be able to according to instructions, but I don't want to.
So she might be able to, but she may not want to. So, you know what? I'm going to go ahead and skip to clip 6, because I feel like clip 6 kind of just puts a pin in what I think the whole media tour was designed to do. So go ahead, Yumiko, please. Clip 6.
Did the grand jury recommend an indictment of former President Trump?
I'm not going to speak on exact indictments. I don't think that there are any giant, that's not the way I expected this to go at all. And I will say that when this list comes out, there are no major plot twists waiting for you.
That just raises more questions of
I know, I'm sorry.
And that includes of the former president, potentially.
Potentially, it might.
So there you go. I mean, are we going to say something or are we not going to say something? But it seems like there's this sort of flirting with disaster, almost is just like trying to stir up the controversy. And I don't know, is that the job of a foreperson for a grand jury where they're under a rule to keep everything as secret as possible? So if you have a thought on that, do you think that is a possible violation of the rules to keep grand jury deliberations secret? Like I said, some legal scholars have said, no, she didn't say anything that was really a secret. And a lot of legal scholars also agree that it's not exactly the best form for a foreperson, but again, nothing illegal about it either. So maybe you have a thought on it. 877-943-9673. 877-943-9673. All right, let's go to the Villages and let's talk to Catherine. Catherine, welcome to the Attorney Patrick Smith Show.
Oh, thank you very much. I'm glad you have the show. I just found out about it, so this is new for me. And I'm calling in because my husband is Canadian, and he has sons that live in Canada. And I have a trust, and I'm wondering if I can name them as if I pass, can have them be executors of my trust.
So... Excuse me, it's two different analyses, Catherine. One is for successor trustee of the trust, which is a broader interpretation. And then there's the rules regarding serving as the personal representative of the will. But I would say the short answer is there's a possibility for because these are the stepchildren for you, right. Correct? So there's the possibility, although it's been forever since I've actually looked at that statute on stepchildren. And I remember on personal representatives, it is a little murky. But on trustee of the trust, you shouldn't have any issue there. They can certainly serve there, I think, without any issue. And I think on personal representatives, I'm going to give you the best probably that I can live on the air. But I also have an office in the Villages. So if you want to schedule a consultation, bring any existing documents in, we'll go over all that, pull down the statute, go over that with you and give you the best answer that we can, okay?
Okay. Can I ask you another question?
Go right ahead.
The same kind of thing. one of his sons has become a resident. He has a green card in the United States. And we're wondering if he could be named as executor of my husband's will because he's written his will in Canada. So again, it's a cross-border thing.
Well, I would be an answer of Canadian law, I think. And I think under Canadian law, you'd have to check with an attorney there and see whether or not that would be an issue. If it were strictly a Florida case, it wouldn't be an issue because a blood relative can serve as your personal representative. So there's no issue there.
Okay. May I ask you about my power of attorney that I got on my husband?
Go right ahead, Catherine.
I'm wondering, because I got a power of attorney here in the United States, I'm wondering if this annuls his kind of mandate that he wrote, the will up there that named his children as like power of attorney. But now, more recently in the last year, I've gotten a power of attorney here because he's having some memory issues.
Yeah, I don't know. I'd have to look at the power of attorney because simply executing a new power of attorney doesn't necessarily revoke the old power of attorney. So I would need to put eyes on all that paperwork to give you a proper opinion on that, Catherine. Hey, Catherine, what station are you listening on up in the Villages?
It's that 102 something.
102.5?
I got it on my computer.
All right.
Well, we went through your website to find it, and it sent me to that. So I'm listening on my computer.
Well, Catherine, we appreciate you listening and spread the word up there about the show, and we look forward to more calls from the Villages, okay?
Thank you.
Have a great day.
Bye.
Bye-bye. All righty. The number to reach out to the office, by the way, Catherine, if you want to do so, 877-754-6764 to be part of the show, 877-943-9673. Let's go back to Lake Placid. Now let's talk to Michael. Michael, welcome to the Attorney Patrick Smith Show.
Thank you.
How can we help you today, Michael?
Well, I comment on the show. You're actually talking about the full person. I don't think she said anything wrong, but I think that she's profiting maybe from being there. I think she should be held accountable for, in some kind of contempt or whatever. She knew the rules. I mean, she's a poor person.
Well, so why would she be held in contempt, though, if what you said's accurate? If she didn't do anything wrong, why would she be held in contempt?
Well, she's actually flirting with giving out information.
That's a fair analysis.
Profit.
Yeah. Yeah, well,
I mean, for profit.
Is it just profit, or is it maybe she's looking for her 15 minutes too?
Yeah. Well, it could go both ways.
Well, right, or maybe it's both.
For both.
Maybe it's both. We don't know. We don't know.
Yeah, exactly.
But if she said, "Hey, this is what we discussed, and here's what's going to happen," we can agree that's a violation of the secrecy. But is sort of this teasing of it? I almost feel like that's worse because you're just sort of stirring up more drama about it. So I don't know. I agree with the analysis that said, hey, it's bad form regardless, even if it's not a violation of the secrecy.
Exactly. Yeah. I think she should be held some responsibility here. She knew the rules.
All right.
And she is flirting with it. And I think that she should be held accountable. But, like I said, it's just stirring up more. It doesn't matter what one side says, the other side's not going to like it, and it just goes both ways. And
well, there you go.
Everybody's got, everybody's got an opinion also, I guess.
That's right. Michael from Lake Placid, we thank you for the legal analysis, sir. Enjoy the rest of your Saturday.
All right. Thank you.
All righty. 877-943-9673. That's your number to be on next week's program, where we will have in studio our special guest, the tax man, Dwayne Bischoff, CPA, will be in studio answering all your tax questions. To reach me at the office, you can do so by dialing 877-754-6764. Check us out on social media, the Attorney Patrick Smith Show on Instagram, Facebook, Attorney Patrick Smith. And again, you can always check out our website, attorneypatricksmith.com. Thank you to everyone who helped so hard on today's show. God bless, stay safe, and go Gators.
The proceeding was sponsored by the law offices of Patrick L. Smith. W282CI Tampa, W271CY Lakeland, W262CP Bayonet Point.
Online at letstalkfaith.com or listen on TuneIn and Odyssey.
Here at Faith Talk Tampa, we've just added a brand new signal to expand our coverage area.